Well, now we need to talk about this practice of real estate, and which is what we're going to do. But before we get into this module, the practice of real estate, somebody might be thinking, well, you skipped the last chapter, which was the math chapter. And I really did not skip it. Because we've already been over most of the math that you need to understand for test purposes. You know, in earlier modules, we went over the real estate property tax math. We did some appraisal math. We did some financing math. And there's still a little bit more we'll do when we get into the state-specific chapters. But my point is, when it comes to the math, that's integrated throughout the material, okay? The only reason you see the chapter or math chapter is just really a bunch of math questions. It's for review, it's for practice. But we just don't have the time dedicated for this course to actually go through that as a whole chapter, okay? That's not real. That's just something I've added for your review, and hopefully that will help you out trying to prepare for math questions. So with that said, so we want to get into this practice of real estate, and this is really kind of a catch-all chapter. We've got a chapter like this obviously here in the national portion, but when we get into the state-specific portion, we'll have another chapter which is what I consider like the catch-all. It's not just dealing with one topic, if you will. It's a lot of different topics that we're going to be talking about to wrap up the national portion of the real estate course. So, y'all, let's take a look. Well, first of all, you see what some of the topics we're going to be getting into here. Obviously, a big one is fair housing. Advertising is always going to be a big deal. Agent supervision, ethics, and then some issues that deal with or involve technology. There's some things you need to understand about that to protect yourself from potential legal issues down the road. All right, so those are some things we're going to talk about. But we're going to start with fair housing laws, or just fair housing in general. Now, when it comes to fair housing, there are many different laws, a lot of fair housing laws that make up the fair housing laws, okay? So the good news is for you and I is you don't have to know or memorize all the laws that make up fair housing. But I will tell you there's two right here that you will see again. You need to know these. And the first of which is the Civil Rights Act of 1866. And it says that act declared that all citizens of the U.S., regardless of race or color, shall have the right to purchase, sell, and own both real and personal property. Again, that's the Civil Rights Act of 1866. Now, I don't know how many of you are familiar with how our legislature, Congress operates. But typically what will happen is, whichever side, whether it be Republican or Democrat, whichever side is in control of Congress, and this has sort of always been the case, but it's just gotten a lot worse, it seems like to me, here in the last several years. But whichever side is in control of Congress and passes a law, the other side does not like it. And again, that's probably always been the case. But nowadays, what you tend to see, it's not that they just don't like it or agree with it. Now that we claim that it's either illegal or it's unconstitutional or some issue with the law, and shouldn't even be a law. Well, when we have situations like that, how is that resolved? Well, then they have to test the law in court, and and typically it will go to the Supreme Court, and the Supreme Court will either rule that this law is legal, it is constitutional, or it's not. Okay? But that seems to be what happens very common nowadays. Again, no matter what party is in control, the other party is going to contest anything that's passed during that tenure. Well, the Civil Rights Act really kind of was under the same scrutiny here. Because y'all, when they passed this act, which obviously is now the law, again, it was passed in 1866, roughly 100 years later, it was contested in court. In other words, contesting the legality or the constitutionality of the law. So it went to the Supreme Court, and the Supreme Court ruled that it is legal and it is constitutional. And y'all, this suit was called Jones v. Mayer. And y'all, you need to remember this. Y'all, Jones v. Mayer, that was the Supreme Court decision of 1968 that upheld the Civil Rights Act of 1866. So, all right, so just to rehash real quick, what is it I need to understand here? Well, you need to know that the Civil Rights Act of 1866 was passed, basically saying you cannot discriminate against allowing people to buy, own, sell both real and personal property. Okay? The Supreme Court decision that upheld that act was called Jones v. Mayer. Y'all, so you need to remember, it was a Supreme Court decision of 1968. Y'all, roughly 100 years later, they contested this. And the Supreme Court upheld the Civil Rights Act. And now, because of this Supreme Court decision, now under no circumstances can anybody discriminate based on race. All right. So I'm going to tell you everything on that slide. Obviously, it's in your material as well. But everything on that slide is very important for test purposes. No question about it. All right. So the next thing we need to take a look at is, y'all, it seems like any time Congress passes any law, much less fair housing, but pretty much any law, you're always going to have some that are trying to circumvent the law. They don't like the law. They don't want to have to comply with the law. So we're trying to figure out a way to get around the law. So what you would have people doing when this fair housing law was passed, they were saying, well, what I'm selling is a condominium. It's not a house. So therefore, I should not have to comply with fair housing. Or I'm renting an apartment. It's not a house. So therefore, I shouldn't have to comply with fair housing. So then Congress basically had to go back and define housing. And you see it in your material there. The types of properties that would be considered housing and subject to fair housing laws. And if you look at that information in your material, I would have to say pretty much anything that what might be considered habitable would fall under fair housing laws. I think they've pretty much laid it all out right there. But then there are some prohibitions. Well, what's a prohibition? Y'all, prohibition is anything you're prohibited from doing. And to go along with these prohibitions, we've come up with a group of what we call protected classes. Now, y'all keep in mind what you're looking at right here are federally protected classes. Is it possible there could be additional protected classes that have been adopted in your state, or in different states might do or require different things? And I will tell you that's the case. But what we're looking at right now is only the federally protected classes, and that's what you need to know for test purposes. And I highly recommend you memorize these protected classes. Okay? and a couple of them we need to talk about. But y'all, you see them listed here: race, color, religion, sex, handicap, familial status, national origin, and sexual orientation. Y'all, a couple of those we need to talk about for clarification. But before I do, I want to re-emphasize how critical it is to know these protected classes, because they're going to ask you the question, and they may ask you more than one question to make sure you know what's a protected class, meaning you cannot discriminate against any of these protected classes. They might say, which of the following is not a protected class or is a protected class? And I'm just telling you right now, if you don't know for sure what a protected class is, I promise you they're going to have some things listed there. You're going to think, well, if that's not a protected class, it should be. Well, the question's not asking what you think should be. It either is or it isn't, all right? And I'll just tell you one, for example, that it seems like almost everybody thinks is a federally protected class, and it's not, and that's age. Age is not a protected class. And I know they like to use that on the exam a lot. But age is not a federally protected class. Now, some states may have adopted it as a protected class, but that's not what we're dealing with here. We're only dealing with federal protected classes. And again, you see what they are. Now, you'll notice this last one here, sexual orientation. I need to talk about that a little bit. In fact, let me just say right off the bat, sexual orientation is not a federally protected class. Please hear what I just said. It is not a federally protected class. Well, then, Frankie, why did you put it there? Well, good question. If you are a realtor or if you become a realtor, then you need to pay attention here. Without getting into the weeds, we'll do this a little bit later. We got a little bit to talk about concerning ethics, and we'll talk about that a little bit later. But there is, and a lot of people don't realize this, but there is a difference between a real estate agent, someone with a real estate license, and a realtor. There is a difference. They are not the same. But you hear those terms used interchangeably. Well, so you're a realtor? Well, maybe not. Just because you have a real estate license does not mean you're necessarily a realtor. Well, to become a realtor, you would have to join the Association of Realtors. Okay? And that's not a mandatory thing for most, anyway. It's just not mandatory. So it's a choice you might make when you get your real estate license. You might choose to join the Association of Realtors. You might choose not to join the Association of Realtors. And there are a lot of reasons to join or not to join. But whether you join or not, that's not what I'm really getting at here. But the point I want to make is if you decide to join the association and become a realtor, the association has adopted what they call a code of ethics. And it's a pretty significant code of ethics. In fact, it's a very significant code. So why does that matter? Well, if you have your real estate license, obviously everybody has to comply with licensing laws. Everybody, whether you're a real estate agent or realtor, you must comply with license laws. But realtors have taken this a step further. They've actually come up again with this code of ethics. And if you choose to join the association and become a realtor, then you must also agree to be held accountable to a code of ethics. I'm telling you, there are things that a real estate agent can do that a realtor cannot do, because it might be considered unethical for the Association of Realtors. So just keep that in mind. So why do I have it here again? So y'all, part of that code of ethics mandates that you may not discriminate against someone based on their sexual orientation. So again, that's not a federally protected class, but if you choose to become a realtor, this could, I don't know why anybody would want to discriminate against anybody else, to be honest with you, but just in case you just decide I want to discriminate, here's some you better not discriminate against. But sexual orientation is a no-no if you are a realtor. Okay? So, hopefully that makes sense. But the point, I want to make sure this is clear. If they're asking you which of the following is a federally protected class, is sexual orientation a federally protected class? No. Then frankly, why do you put it here? It's just the only place I could think to put it, because it relates to this non-discrimination, but it only applies to realtors, not all real estate agents. Okay. All right. Hopefully that made sense to you. And if you're not sure what some of these other protected classes are, we're going to be talking about those as we go through this section. The next thing you should see are some additional protections for those with disabilities. Obviously you cannot discriminate against someone because they have a disability. And and you see here on the slide as well as in your material, just some things that they may or will consider a disability that you cannot discriminate against. You can look. I'm not going to sit here and read all of them, but I will tell you one that I tend to get a lot of questions about. People say the alcoholism, chronic alcoholism, that's a disability. Well, apparently, yes. What this means is this. To be able to claim the disability, assuming someone is an alcoholic, you must have successfully completed a rehab program and you're no longer drinking alcohol. Once you successfully complete that or achieve that, then it's considered a disability that someone else cannot discriminate against. If I used to be a heavy drinker and I'd tear up property and just a mad person when I get drunk or whatever, you couldn't refuse to, assuming I went to rehab, successfully completed, I'm no longer drinking, then it's not fair that you can hold my past against me, right? I'm now clean. I'm not doing some of the stuff or any of that stuff anymore. So you can't discriminate against me today because of something I used to do, as long as I've cleaned myself up and no longer have that issue. That's what they're talking about there. We need to talk about a scenario, or at least look at a scenario. And I think you'll find this scenario could be very useful and helpful to you to answer some questions on the exam. But let's say I'm renting a house, or I'm a landlord. I have a property that I want to rent, rather, and I find a potential tenant. They like the property. In fact, they want to rent the property. But we got a problem, and that problem is, this tenant is confined to a wheelchair. And the only way they're going to be able to stay here or rent this property, we're going to have to make some modifications to accommodate the wheelchair. May have to put in a wheelchair ramp so they can get up the steps. May have to widen doorways, both exterior doors and interior doors potentially. May have to modify the bathrooms to make sure they're handicap accessible. Things like that. There just may be some modifications that would have to be made if this disabled person in a wheelchair is going to be able to stay here or live here. Well, then a few questions come out of this situation. First of all, if I'm the landlord, do I have to pay to make those modifications for this handicapped person? And the answer is no, I do not have to pay for it. Now, if the tenant is, if they have the money or resources to do the modifications on their own, then you cannot deny them the right to make the modifications. If you just say, no, you're not modifying this property, now that would be considered discrimination. You can't do that. But again, if they're willing to pay for the modifications, then you have to let them do that. Again, the landlord does not have to pay for it themselves, but they must allow the tenant to do it if the tenant's willing and able to do it. In addition to that, assuming the landlord, if you're going to make these modifications, tenant, the landlord may have a requirement that when this lease expires, I want this property put right back to the original condition, the way it was before you made any modifications. If the landlord wants to do that, which they have that right, they could also require the tenant put up enough money, obviously be held in the trust account, but they got to put up enough money to ensure that there's money there to pay to put the property back in the condition it was originally in. So not only would the tenant have to pay for the modifications, potentially they would have to pay for whatever it would cost to put it back to its original condition. Again, the landlord is certainly free to do that if they choose. The main thing again here is, they can't deny them the right to make modifications to accommodate disabilities. Otherwise that would be discrimination, and that would be a problem. Okay. Now, obviously, at the end of the lease, if you're going to make those repairs, now look, if you're not going to convert it back the way it was, you can't keep their money. In fact, if you're not going to convert it back, you probably shouldn't even be collecting the money to start with. But y'all say they put up, I'm just making up a number, but say they put $10,000 up that's been held in the trust account, and we do all the work. Is now put back into its original condition, and it only cost $8,000. Well, then you got to return the remaining balance to the tenant. You can't just keep all of whatever they put up. Okay. You see a section here talking about service animals, like C&I dogs. For a lot of people, especially if you've got a blind person, they may have a C&I dog to help them maneuver or get around. Well, what if, again, as the landlord, could I have a no pets allowed policy? Yeah, I can certainly have that policy. But when it comes to a service animal, obviously you can't deny a potential tenant that must have a service animal. You cannot deny them. You would have to allow that dog or whatever animal it is, if it's considered a service animal, then you got to let them in. You can't just stand by your no pets allowed policy and say you can't stay here. Again, that would be discrimination. Now, we'll tell you there is some, and by the way, that's what you need to know for test purposes. If it's a service animal, you got to let them in. You cannot deny the tenant if they have a service animal. Now, having said that, what we're, at least in the market I work in, there seems to be some confusion on, what's a service animal? And who gets to decide what's a service animal? For example, some people feel like that they need their dog with them to keep them calm. They can't function without their dog here. Okay. So what they might do is they'll go talk to their private physician or doctor, and then the doctor will say, yep, this person needs that dog with them, to help them control or contain emotions or whatever the case may be. But what a lot of people have claimed is that's not a service animal. That's really all you've got is a doctor's excuse that says you need to have a dog. Well, if the tenant has a doctor's excuse, does that doctor's excuse render the dog a service animal? This is where there seems to be a lot of, at least in our market, maybe where you operate, the state has more clearly defined rules and regulations on how that works, and hopefully they do, but it's not here. Lot of confusion there. Some people say, well, no, for it to be a service animal, it has to be a federally registered animal. I don't even know where you register an animal federally to be a service animal, but I don't want to get any deeper than that. But I'll just for test purposes, if they indicate that in the question that the tenant has a service animal, then y'all assume it's a service animal, and you got to let them in. You cannot deny them the right to rent because they have a service animal. All right. One of the protected classes was familial status. And I like to, in fact, I ask all the time when I'm doing live classes, what is familial status? What does that mean? And a lot of people say, well, that's dealing with whether you're married or divorced or separated and stuff like that. That's got absolutely nothing to do with it. Familial status would be anybody that has custody of a minor. Okay? Well, we know the legal age is 18. So if you have custody of anyone under the age of 18, then you're considered to be of familial status, right? So what are we talking about here? So when we say you cannot discriminate against familial status, then what is it you cannot discriminate against? Obviously, children, minors. You cannot discriminate there. Now, I don't know how deep they'll get on the exam, but just in case, I want to throw this out there. Say you've got an expecting mother. She's pregnant. She doesn't have any children, at least at this point, none that are born. But she's expecting a child. Well, if you're expecting a child, then you are also considered to be a familial status because it's expected you will soon have custody of a minor. So a pregnant person, someone expecting a child would also fall under familial status, and you could not discriminate against them. But then, next thing you see are some exemptions when it comes to the familial status. There's actually 3 examples or exemptions where you potentially could discriminate against familial status, and you need to be familiar with these. The first would be any HUD-owned properties that have been set aside for the elderly. Again, these are properties that are owned by HUD, specifically set aside for elderly people. Then obviously they would be exempt. They may say, no, if you've got small children or minors, then you're not going to be able to stay here. This is just for the elderly. But then, these next 2, are dealing with senior citizens communities. If hopefully you've heard of those or familiar with it. But there's 2 types of senior citizens communities. But just be clear, if it's a senior citizens community, then obviously it's for senior citizens, for elderly people. It's not for young children or minors to be staying here. But the 2 types, you've got one type of community that would require that everybody must be a minimum of 62 years of age or older. If you're not 62 years of age, then you're not staying here, period. I will tell you, actually several years ago, I actually had to deal with this. Thank goodness it wasn't my client, but anyway, apparently an elderly couple bought a house in a senior citizens community, and they bought it because the husband was at least 62, but the wife was not 62 yet. And they got a letter shortly after moving in Babies and husband, we glad to have you here and hope you have a good time living here. But your wife is going to have to go. She cannot stay. She is not 62 years old. I've had people say, well, he might have did that on purpose. But anyway, y'all, so when they say it's 62 and older, y'all, that's everybody. Just because you have one spouse that's 62, the other one's not, y'all, the one that's not 62 is not going to be staying in that community, period. So just be aware of that. But then the other one, it says there has to be at least one person that's 55 years of age or older in at least 80% of the units. And obviously the association there would have to keep up with this, because they got to make sure in at least 80% of those units, there better be at least one person that's 55 years of age or older. Y'all, so that suggests that not everybody has to be 55, but there better be at least one person that's 55 in at least 80% of the units. Y'all, otherwise they could lose their senior citizen status, and then obviously they could not discriminate against familial status. But again, if it's property set aside for the elderly, senior citizens, communities, y'all, they are exempt from familial status. Well, now we need to take a look at the enforcement agency. Obviously, if we have laws, somebody has to enforce or even be able to prosecute those that violate the law. Well, what agency will do this? Well, that's HUD. At least at the federal level. HUD enforces fair housing laws at the federal level. Now, when we get into the state-specific portion of this course, depending on what state you're in, pretty much, to my knowledge, every state has a state-run agency that also will enforce fair housing laws, again, at the state level. But that will vary and is different state by state. So when we get in state-specific part, we'll actually talk about what state agency it is that enforces fair housing laws. But right here, we're talking about the federal, and federal is enforced by HUD. Now, if you don't know what HUD stands for, obviously it's an acronym. Make sure you know what it stands for: Housing and Urban Development. I actually had a prior student come up to me after taking the state exam saying, Frankie, there was a question they were asking about housing and urban development. I never heard of that. We never talked about that in class. What is housing and urban development? I said, well, do you not recall us ever talking about HUD? Oh, yeah, I remember talking about HUD. Well, that's what that is. So, if you don't know what HUD stands for, pay attention to it, because, they may not use the acronym on the exam of HUD. All right. But anyway, HUD enforces fair housing laws at the federal level. Now, obviously, if anyone feels like they've been discriminated against, should they file a discrimination complaint? Well, yeah. Well, you see here that there are some time limits on when you can file a complaint. And at least at the federal level, again with HUD, here HUD says you have up to 1 year from the time of discrimination. So whatever day the discrimination took place, you've got up to 1 year to file a discrimination complaint with HUD. When HUD receives a complaint, at least initially, they're going to just try to get both parties to come together. We're going to try to reconcile. We're going to try to just make everybody happy. Can we figure out a way to do that? And obviously we can. That's the best way to handle the situation. But if we can't make both sides happy through reconciliation, then now the complainant will have up to 2 years to file action in court. Then obviously we'll let a judge and a jury decide how the issue is going to be handled or resolved or whatever. So you need to remember, at least at the federal level, you got up to 1 year to file the complaint. And if we can't get it resolved within that time period, then the complainant, you have up to 2 years to file action in court. Y'all pay attention to that, because I'm going to tell you, y'all, there's when we get into the state specific part, whatever organization at the state level in your state, y'all, they're going to have something very similar, like time limits. But I know, like in my state, it's not the same amount of time for the state level, at the state level, as it is at the federal level. So you'll want to keep those straight. And again, we'll talk about the state agency when we get to the state specific part, but y'all, you need to remember that. That's what I'm trying to tell you. Make sure you remember that. All right. So now we look at what are some of the penalties for those that violate fair housing laws. Well, obviously you would be you could be liable for actual damages, if there are any actual damages caused by it. But even if there's no actual damage, no monetary loss, there's still humiliation, pain, and suffering. And that could be a lot of money right there by itself. They could also require the property be made available to the person. What they're talking about, obviously, if you had a member of a protected class trying to rent a particular property, but they were denied the right to rent the property due to some discriminatory reason, then obviously, file the complaint. Then they may require that property actually be made available to the person that was actually discriminated against. But then, when it comes to the real estate companies, obviously we're going over all these fair housing requirements, because it's illegal. If you're a real estate agent, you better not be discriminating against anybody for any reason. And quite frankly, you shouldn't be doing that regardless, right? Whether you're a real estate agent or not. But if you're a real estate agent, you better not be discriminating. Because, you see here, the company that the licensee belongs to, if a licensee violated the fair housing laws, whatever company they're licensed with, it says, for the first offense, it's almost $22,000 fine. If there happens to be a second offense in that office within 5 years of the first, then it's a little over $54,000. And if there's ever a third offense within 7 years of the first, it would be over $107,000. These are some pretty steep penalties or fines here. And keep in mind, this is just a fine that you owe the government. This does not include damages, humiliation, pain and suffering. That's going to be a whole nother matter. This is just the fine the real estate company's going to have to pay. But then it also says, now the individual licensee that actually committed the violation, that individual is going to have to pay the same fine. If it was their first offense, $21,664. If it's their second offense, $54. And so forth. The only difference here is, for the individual, it does not matter how long it's been since your last offense. Okay. So, for example, for the real estate company, the $54,000 would apply only if it was a second offense within 5 years of the first, or 7 years for the third offense. None of that matters for the individual. And I will tell you, at least in my state, it's kind of interesting that they even list what the penalty is for second offense, third offense, and so forth. Because I'm going to tell you, in my state, when you get caught the first time, you're done. You're not going to get you will not, you're going to lose your license. You're going to be without a fair amount of money here, obviously. So it's kind of interesting. Apparently some states, they don't take your license and whatnot because they say that you might have a second or third offense or whatever. But I don't know that the actual dollar amount of the fine is going to be that big a deal for test purposes. I don't think so. But they could ask you that for sure. But anyway, all right, moving on. So what happens when you file a complaint? Well, we really already kind of talked about that. Either HUD or whatever the state agency is, if it's filed at the state level. They're just going to bring the parties together and try to reconcile, try to work it out between the parties. But if we can't get it worked out, we cannot reconcile, then obviously the complainant does have the option to take it to court, and we'll let a judge and a jury decide exactly what's going to happen or how it's going to be handled. Okay. Next thing you should see are 3 specific violations of fair housing laws. There's 3 specific violations. You better know these 3. You're going to be tested on them. Well, the first violation is what we call block busting. It says block busting is when one is preying on fears, on their prejudices, trying to induce someone to sell their home due to a protected class that might be buying other property in the area. That's block busting. And so to give you an example of how this might work, let's say a real estate agent contacts a homeowner and says, "Hey, look, homeowner, I just wanted to touch base with you to let you know, obviously your home has been, over the last several years, has been appreciating very nicely. So your home has considerable value as of today. But what I'm not sure you may not be aware of the fact that there is a protected class that seems to be buying property all around you and moving into the area. And the more of these that continue buying and living around you, that's going to start to have a negative impact on your property. Your property is going to soon be depreciating in value. So what you might want to consider here, homeowner, is selling it now before the prices start coming down. And oh, by the way, I'm a real estate agent and I can help you sell it. That's block busting. That's nonsense, right? That's preying on people's fears and prejudices by trying to persuade or induce them into selling their house due to some other protected class that might be buying property in the area. Obviously, that is illegal. That is block busting. Don't be doing stuff like that. Another violation is steering. Steering is when you as the real estate agent kind of decide where you think your client would best be suited, what area of town they should live in, based on their race or color, their religion, any of these protected classes. That's not up to you to decide where someone needs to look at potentially buying or living down the road. That's not your job. Your job is to you ask the buyer, where is there an area of town or part of town or side of town that you think you would most be interested in, and then go find properties for them wherever they say they want to be, right? You can't just say, well, I don't think you're going to fit in very well over there. I don't think you're going to enjoy living there very well. But I do think over on the other side of town, I think you'll be much happier. You're steering them, and that's a no-no. That's illegal. Don't be doing stuff like that. And then the third violation is redlining. And redlining was a form of discrimination at the time by lenders. A lot of lenders did this. It's illegal today, so hopefully they're not still doing it. But what would happen here is, say you got a member of a protected class, would go to the bank looking to borrow money to buy a house. Well, the loan officer would say, oh, well, we would love to help you. Do you have a particular house in mind? And we're thinking about 417 Maple Street. We're thinking about buying that house. Well, then the loan officer, they would have a map right here on the wall. So it ain't like it was hidden or anything. You got to have a big old map of the town or city right there on the wall. And all around that map, you might see a few or maybe even several areas around circled in red. And and then once they got the address of the property this person was interested in, then they would go find that address on the map, and if it fell inside of one of these red circled areas, the loan officer said, well, we cannot loan you money there. But if you want to live up here or down there or over there, we'll loan you money all day long, but we cannot loan you money there. That was redlining, and obviously that is also illegal. It can't be doing that kind of nonsense. So those 3 violations, you better know all 3 of those. They're going to ask you about them. HUD logos. Hopefully you're familiar. There should be a picture, I think, in your material, in your book, of the HUD logo if you're not familiar with it. Remember the HUD logo, it's got like a picture of a house, and then right underneath it says fair, equal opportunity for housing and stuff. That's the HUD logo. So what's the big deal about the HUD logo? Well, should you include the HUD logo in your marketing or advertising? Like if you're going to have a business card or your website or flyers, brochure, whatever. Any kind of marketing or advertising you do, HUD highly recommends you include that HUD logo, which basically suggests the fact that you advertise the HUD logo, you're in fact saying, we do not discriminate here. Not a bad idea. But it says we highly recommend. I say we, HUD, highly recommends you use it. Does the law require you to include that HUD logo in your marketing or advertising? No, it does not. But the reason they highly recommend it, and this is what you better be careful of, if anybody should ever file a discriminatory complaint against you, and you don't use that HUD logo in your advertising, then by law, the fact that you did not advertise we don't discriminate, then the assumption is then you must discriminate. And that will be used as de facto evidence in court against you. So this could really come back and hurt you. Whether you're discriminating or not, that's going to be used as evidence that you were discriminating, because you don't even advertise that you don't, so we must assume that you do. That's basically what they're saying here. So be careful with that. Now, when it comes, so assuming you're going to use the HUD logo, there are laws that dictate how you can use it. For example, business cards, and I'm just using that as an example because that seems to be the more common form of advertising. People have a business card. If you're going to put that logo on your business card, again, we highly recommend it as well. You can't just have it so small that you can't even see it. People won't even pay attention to it. But yet you can say, oh, but it's there. I got it there. No. The law says if you're going to have the HUD logo must be of at least equal size to any and all other logos that you have on the business card. There are a lot of real estate type logos. There's the Realtor Association logo. There's the MLS logo. You might have your company logo. There's a lot of different logos that could be on a business card. There are a lot more, I'm just telling you. And for you to have other logos this big, and then the HUD logo down like this, are you saying that this is not as important as these? That's the way it's going to be perceived, whether you meant that or not. So just make sure they're equal size. And then lastly, what it's saying here about the logo, y'all, if you choose to do this, I don't know why you would. But y'all, what they're saying here is, y'all, you can y'all, that HUD logo, remember it's got like a little picture of a house, and then under it, equal opportunity. Well, HUD saying, y'all, if you don't want to use the house, you can just use the words, y'all, equal opportunity, y'all, or whatever it says. I think that's pretty close to what it says. But y'all, you can use the words of the logo without the house being there, but you cannot have just the house without the words. You cannot do that. Okay? If it's me, I'd just put the whole logo. I don't know why I'd be splitting the logo up anyway. All right. Y'all, next thing you see here is where HUD's advice to prevent advertising violations. Y'all, if you look at that first bullet, y'all, it says HUD recommends a variety of human models from minority and majority groups of varying ages to assure compliance with advertising guidelines. Y'all, what they're saying is, y'all, if you just take a picture of a family, a white family, a black family, whatever race they are, whatever color they are, whatever, then the assumption could be reached that, if it's a white family, then we're only asking or looking for white families to live here. Or if it's a black family, we're only looking for black families here. They're saying you need to mix, have a variety of models. In fact, you see that, even on TV commercials nowadays, you see a lot of what appears to be interracial. You might have a white husband and a black wife, and one black child and another white child, or whatever. Trying to make sure they've got a variety so that no one can assume that you're preferring one race over another race, or one color over another color, or whatever. So be careful with that. But then in that second bullet, it also says it's unlawful to suggest a more suitable bottom floor to a physically disabled person, or to suggestively steer them to a community better equipped for their condition. That's a no-no. I don't know. Some of this stuff, kind of defies a little bit of common sense to me. But, if there's someone that is, with a disability, I would, I hope this doesn't sound wrong, because I certainly don't mean it that way. But I would, if it were me, if I had a disability and you have a bottom floor and I don't have to try to go up to the third floor or whatever, that's what I would prefer, me personally. Now look, if I'm an agent and I just let you know, now we do have a unit on the bottom floor. Obviously if I don't care which unit you want. I'm just letting you know there are options here. You can choose whatever you want to choose. But here they're saying, it's illegal to even suggest there's a more suitable floor. I don't really understand it. But look, it doesn't matter what I think. That's what HUD says, and that's what you got to pay attention to, right?